Yeah. No, but you don't have to. Oh, really?
Okay, good morning, everybody. You're in first appearance magistrate court. Today you'll be informed of the charges and we're going to determine if there's probable cause. Today is not your trial day. Please do not talk about the facts of your case. Everything's being recorded. You have a right to remain silent. Anything you say can and will be used against you. You also have a right to an attorney. There's a public defender at the main jail, and there's Mr. Reedy here in the courtroom. If you have a private attorney, please let me know when you step up to the podium. We're going to call a couple cases at a turn. We're going to call on page 28. We have a private attorney for Tyrell McCall, please.
Good morning, Your Honor. How are you?
Good morning. How are you, sir?
Good, thank you. Judge, I am Mike Gottlieb on behalf of Mr. McCall. His father is present to my left.
Good morning.
I've read the warrant. There seems to be probable cause, so we'll go ahead and stipulate. It is a purse PBL. I'm going to ask Your Honor to exercise discretion and set a bond. Just a couple of things I'd like to point out in the affidavit. There's two individuals who allegedly committed the crime. My client is not the person.
Hold on, let's get him.
Oh, I'm sorry.
Does anybody know where he is? Is there a Tyrell McCall? Do you know if he's at the main?
He was all the way in the back, sir. Come on up.
Thank you.
Your private attorney, Mr. Conrad. Your private. Okay, sir.
Hello.
If you don't mind, for his benefit, I'll repeat what I said.
Sure, no problem.
All right, Judge.
The record is
Sure. Michael Gottlieb on behalf of Tyrell McCall. His father is present to my left. Judge, again, I'm going to stipulate that there is probable cause as I see it in the warrant, although I do think that there are a couple things I'd like to bring to the court's attention. Number one, there's two individuals who allegedly committed this crime. My client was the person who was alleged to be the distractor to the people in the store. It was not meant to be an armed robbery. It was supposed to be more of a theft type crime. They used a box cutter to cut phones off of the those electronic cords or whatever they are that keep them. Unfortunately, the female who had the box cutter was confronted by an employee and she brandished the knife. My client did not brandish the knife. I think that's an important distinguishing factor. As well, his father's here to tell you that the police came to the house. They said, "We're looking for your son." The father called the son, went to pick him up, brought him home, called the police, and said he's home now. The police came and they arrested him on the warrant. So I don't believe him to be a flight risk. He does have some priors. The most significant, I believe, is a grand theft. There's also a battery. I'm asking, Your Honor, he lives at home with his parents. The parents are obviously honorable citizens. He did the right thing in this case, asking you to exercise discretion and set a reasonable bond. I spoke to them yesterday. I know it's not a high amount, but what they can afford is around $5,000. But I would ask the court to do pretrial release and an electronic monitor as well to ensure that he comes to court. No.
State his name for the record.
State your name for the record.
Jackie McCall's
Your Honor,
senior.
is the state going to have an opportunity to, before you take testimony from a witness? Okay, I didn't know if he was, I'm just at, if I wait till it starts, then, you know, I didn't know if the court was asking for his name to put him under oath.
The father was just going to say he's going to make sure the son stays home.
No, I didn't, I just wanted, you mentioned him, so I just wanted him identified.
Understood.
And I didn't hear, so I wasn't sure.
Okay.
Thank you, Your Honor. No, it's okay. I apologize.
That's okay, no problem. All right, so Mr. Linder, what say you?
Your Honor, this is, Mr. McCall has been arrested as a principal.
Sorry, no,
Mr.
sorry about that.
No, it's okay. Mr. McCall has been arrested as a principal to a punishable by life offense, robbery with a deadly weapon. I would argue for first appearance purposes that there is proof evident or presumption great. As a principal, certainly the elements are satisfied by the allegations. And as far as the weight of the evidence, Your Honor, Mr. McCall was identified by his own girlfriend from video surveillance taken from the scene and identified in a double-blind photo array with 100% certainty by the alleged victim. And, Your Honor, I would note that this wasn't just his co-defendant. This wasn't just a matter of brandishing a box cutter, but the allegation is his co-defendant actually swung the box cutter towards the alleged victim, Your Honor. And of course, as the court realizes, even though Mr. McCall might not have been in possession of the box cutter as a principal, he certainly faces the same liability as his co-defendant. We would be asking for a no bond hold under Isaza v. State.
That's all, Judge.
State, I would like to know, what are his priors?
Your Honor's criminal history is he pled out a resisting without violence and possession of cannabis just on March 19th of this year. 2013, a possession of cannabis. 2013, resisting without violence. 2012, grand theft and resisting without violence. And it does appear there was a violation of probation on that case.
And that was without violence, right?
Yes.
All of them?
Yes.
All right, just wanted to know.
No, of course.
All right. Mr. McCall, I have reviewed the probable cause affidavit in your case, and I find probable cause. I further find the proof of guilt to be evident or the presumption great. I do want to talk about bond in this case. So does anybody, you want to be heard, Mr.?
Your Honor, yes. If the court is inclined to set a bond, then we would be requesting, say we'd be requesting a $50,000 bond, pretrial release with a GPS monitor, no victim contact. Your Honor, I would also note there's no reason, since it does appear that Mr. McCall and his co-defendant were acting in concert, there really is no reason to believe that he didn't realize that she had a box cutter on her. And obviously, that's where the concern is, that they're bringing a weapon. That's why robbery with a deadly weapon or robbery with a weapon is such a serious offense, because even if the intent, and I'm not saying this, but even if the intent wasn't to use it, it's there to use, and that creates a very dangerous situation as opposed to when a weapon is not brought into the equation.
I'd just like to address that speculation briefly. It's there to use to cut the device free. There's no evidence or proof in any way, shape, or form that my client had any knowledge that she was going to use it as an actual weapon as opposed to a burglary tool, if you will. So I think that that's an important consideration. He's not the person who had the knife, and he's not the person who used it as a weapon. It's more or less a tool in this case, and that's how it was used until she was confronted. In addition, Judge, just one other factor. My client's father is disabled, lives at home, stays at home all day long, so he can be with the child. And again, he did the right thing and surrendered the child. In terms of the monetary bond, I'd really like you to take that into consideration because his disability also impacts the ability to post a significant monetary bond.
There is going to be no victim contact in state. This is the Verizon wireless store. Is there anybody in particular you'd like to state an individual?
We would ask that include any and all any employees of this store, and we'd note specifically a person with the initials. One moment, Your Honor. MB.
That's M and B as in boy?
Yeah.
Okay.
Mike Bravo, right?
Yes, ma'am.
All right, so this is what the court's going to do. The court is going to do, does your client work or go to school, or what does he do?
He lost his job recently, Judge.
Court's going to do GPS GPS level 2, there's gonna be no victim contact, direct or indirect, and there's no return from the Verizon to the Verizon wireless store. You are to maintain 1,000 feet at all times. I'm assuming he doesn't live within 1,000 feet of the Verizon wireless store.
That's correct, Judge.
Okay, and that's a Verizon wireless store at, get it? 3656 West Hillsborough Boulevard, Deerfield Beach, Florida. So GPS level 2, no victim contact, and no return, and maintain 1,000 feet from the Verizon wireless store, and no contact with any of the employees at this Verizon wireless store, and also specifically an employee with the initials MB. Direct or indirect contact, sir, means you can't call, text, write, anything on social media, liking, disliking anything, and certainly no third-party contact. Court is going to set the bond at $25,000. Anything else, State?
Nothing further from the state.
All right, thank you.
Thank you, Your Honor. Have a nice weekend.
You too. All right, good luck, sir. Thank you. You okay? All right, next one is Stephen Wayne Arichai. I think that's how you say it. Is that your name, sir? Oh, I'm sorry. Forgot to sign. Hello, Mr. Origi. You have an out-of-state hold out of Texas for some type of forgery. You're going to be held no bond, sir.
Good luck.
Thank you. Stacy Dalglesh, please.
Reset for PM, I'm being advised, Judge.
Reset.
Your Honor, she's in North Broward. I think she might want to resolve this.
Is she there? Let's see. You want us, to, Deputy, you want us to set Stacy Dalglesh for this PM docket?
Don't have her here.
All right, well, we'll just reset her for the PM. She's on page, what page is that, please?
2.
Page 2.
Did you call?
Yeah,
You
well,
have the rest, R.A. Sealy.
it is Stacy Dalgleish, Dalgleish, but I'm being told by confinement that it's gonna be reset to the PM docket, okay? Thank you. All right, next one is Michelle Renee Snow, please. Is that a medical reset as well? All right. Good morning, ma'am. You are charged with an ad charge, count 10, driving while license is suspended. First offense, bond set at $100. The court does find probable cause. Does anybody want to be heard with regard to the $100 bond?
Are you going to be able to make that bond, ma'am? Can you bond out for $100? Okay.
Is there are there other charges that you bonded out on, Mr. Reedy?
Let me check, Judge.
Because this is charge 10, I just want to make sure.
Michelle Snow.
I have this as, wait a minute.
Yeah, I don't have an objection to an ROR, Judge.
Yeah, she's going to a program, Mr. Reedy. So
Okay,
we'll
all right.
war. Thank you, ma'am. Good luck to you, okay? All right, next one is Merica McCoy, please. Merica McCoy. Is there a Merica McCoy? MCCOY, please.
Medical reset, Your Honor.
Judge, were you going to call Paula Raciel, R-A-C-L-E?
Yes, I got a message from Mr. McLawrence. He texted me and told me to hold her off,
You what?
to hold off with her.
Okay, okay.
Sorry about that. Sharon, and that's also for, he told me about Willis, please, Rosa, those two. so I'm holding those two off. He'll be here in a bit. Sharon Anita Robinson, please.
Unless they misspelled it, which wouldn't be impossible.
Sharon Anita Robinson.
It should be North Broward.
North Broward. All right, thank you. Next one is Sharona Yale Scott, please. Hey, good morning, Ms. Scott.
Good morning.
You are charged with one count possession with intent to sell, manufacture, deliver cannabis. Bond's been set at $1,000. You also have two capious misdemeanors. One's for possession of marijuana under 20 grams, $500 bond. You also have a possession of drug paraphernalia, capious, for a $500 bond. Total of $200 bonds. Your capious are because of a no-show at arraignment on 12/13/17. Anybody want to be heard with regard to probable cause?
Yes, Your Honor. I would argue that there is not probable cause to establish possession with intent to deliver
On count one?
on count one.
Okay.
The probable cause affidavit indicates that there was cannabis found in Ms. Scott's possession, and then it goes on to say that she was also in possession of several small baggies of cannabis that is consistent with selling illegal narcotics, which is a very conclusatory statement. We do not know how many small baggies there were. We don't know how much marijuana was in each one of these baggies. It could have been 2 baggies. It could have been a personal use situation. Without further details, as far as there's no indication that she was selling anything. She wasn't seen selling anything. There's no allegation that she had any funds that would be consistent with someone who is selling marijuana. There is absolutely nothing here. There's no paraphernalia, no grinder, no nothing like that. I would submit to the court that there is probable cause to find that she is in possession of cannabis, but that there is insufficient detail in this probable cause affidavit to establish that she was in possession of cannabis with the intent to sell it, without more detail.
Okay, thank you. State.
It's fine.
Okay, so no PC on count one. You want 24 hours?
Well, Your Honor, I'm conceding that there should be probable cause for possession.
Yes, I would agree with that.
Thanks for clarifying that, Mr. Windsor. Okay, and based on that, you say the bond should be?
Fine with the $100 standard bond, considering that she's out on a same charge and failed to appear in court.
Okay, defense, any argument?
Judge, regarding a bond, therefore, if I understood correctly, she would have a $100 bond on counts 1, 500 on 2, 500 on 3.
Yes.
She's already reached out to her parents. Her father is retired, and from her conversation with her father, for some reason, they don't think they'll be able to post her bond. Having said that, Judge, she's on disability. She's 32 years old. From my, I don't know what was the circumstances as far as what court date she missed, if it was arraignment. From what she informed me, she nor her family know anything about the criminal justice system. When she originally got the charges on counts 2 and 3, they did not know what was going on. From what she informed me, she reached out to some local attorney. She doesn't remember the name, and the local attorney kind of gave her some advice as far as, in a nutshell, don't worry about it, and she took it to heart. It's not like she tried to deliberately misquote or anything like that. I tried to explain to her that was the incorrect advice. If there's any matters pending before Broward County, it is her responsibility to make sure to come to court and be in court. Having said that, Judge, I'd ask her at this time to consider releasing her on pretrial release so that she can be supervised. My understanding from what she advised me, and certainly the state can verify, she has no prior contacts besides these. These are nature, Judge. I'd ask you to, if the state can verify these are her first ones, would you consider releasing her on pretrial release?
Driving a 2018 Nissan, that it is her vehicle. It would appear there are financial means.
Let me ask you her.
Judge, it's not for financial reasons. Like I said, they could not post her bond. When they reached out, just like they don't know anything about the criminal justice system. So when they're giving that advice, they take it to heart. Like that attorney that she consulted with, that's horrible advice. They reached out to, I guess, a bondsman. They said that they would have to put for collateral their home They go, well, we don't own our home free and clear, so how can we do that? So then they said, we can't bond you out because we don't own our home. I think something along that nature. So there's a lot of confusion because they've never been exposed to the criminal justice system, Judge. Rather than her spending more time in custody, have her released on free bail so she could be supervised.
Okay, ma'am, I'd like to, is your address 3574 Southwest 49th Place?
Yes, ma'am.
Is that Hollywood or, it says Lauderdale, it doesn't even say Fort Lauderdale.
It will probably say Fort Lauderdale or Hollywood.
Okay, which one is the correct or the better mailing address?
Fort Lauderdale, ma'am.
The probable cause affidavit does list it as Fort Lauderdale, Judge.
Well, the booking sheet just has it as Lauderdale, but the
Yeah, I know, I saw that.
habeas has it as Hollywood. Is that still, it has two different zip codes. Is it 33021 or 33312?
333, ma'am.
I'm sorry,
33312, ma'am.
That's not Hollywood?
It's Hollywood for Lauderdale, but when you mail it, it's straight Lauderdale.
That's weird.
It's weird, yeah. We're like in.
We can hear you.
all right, this is what the court's gonna do. The court is going to ROR and put her on pretrial release. She has to report the the one time in person, and just call in twice a week. And that's it.
Thank you, Judge.
She does have to show up within 24 hours, Mr. Romero. Ma'am, if you.
Your Honor, Your Honor, we're going to request drug testing, considering that both cases are for the same offense.
I understand, but I'll let the division judge decide that. So, one thing, ma'am, you're just gonna have to call in twice a week. And if you move, you need to notify your attorney and the clerk of court immediately in writing with the case number in all your cases, not just the one case. Now you have two cases. Okay? All right, and
Yes,
she's gonna
ma'am.
have to
Thank you.
report Mr. Romero within 24 hours of her release. Thank you.
Your Honor, we have, go ahead.
Excluding weekends, right, Judge?
One moment. Yes? No, just the one case, the first one, that she has the habeas. Yeah. Yes. Well, the other one is ROR. They're all ROR. I'm only putting her on pretrial release on the two habeas, okay? Thank you. All right, we do have some family here.
Yes, Judge. On Eugene Suggs, page 23 of the court docket, kind of toward the end.
I'm sorry, Mr. Romero, you were asking me something and someone else was talking to me. What were you saying?
I was just saying, of course, excluding weekends, correct? Because tomorrow is Saturday?
Yeah, pretrial is not there, so on Monday. But I meant within 24 hours excluding the weekend, as usual, or holidays. All right, I'm sorry, Mr.
On Mr. Eugene Suggs, Your Honor, he's on page 23. He has family members here.
And we also have family on Jermaine White.
We're waiting for his mom to show up.
Oh, okay, because I have family here. All right, let me pull Suggs. Give me a moment. Okay, let's call Eugene Suggs, please.
He's here at Main, Judge? I have to wait to see her, okay?
Good morning. Okay, please state your name.
Elise Fields,
Fields.
correct.
Okay, and your relationship to Mr. Suggs, please?
Mother.
Good morning.
Good
And your name, sir?
Kevin Fields.
Same spelling of your last name?
Yes.
And you are you his brother? Nephew, okay. All right, Mr. Suggs, good morning, sir. You are charged with possession of cannabis, 20 grams or less, no bond required, so it's basically an ROR. Count 2 is possession of MDMA, which is ecstasy. There's been a $1,000 bond set. You do have counts 3, 4, and 5, which are probation violations, and you are going before your division judge, Judge Michael Rothschild, on April 17th at 8:30 a.m., so that's this coming Tuesday. You are going to be held no bond on counts 3, 4, and 5, which are the violations of probation. Does anybody wish to be heard with regard to probable cause or of $1,000 bond on count 2?
In light of the fact that Mr. Suggs is being held no bond on counts 3, 4, and 5, we have no argument, we have no probable cause argument, and I'd ask the court just to leave the bond in place.
Okay. Is there anything you'd like to state, ma'am, or sir?
Read the charges, so I don't guess so.
Really, he wasn't even in.
Don't discuss the facts of the case.
Okay. All right, Mr. Linder, anything?
No, Judge.
All right, court is going to set the bond on count 2 at $999 based on the fact that he has 3 no bond holds. Thank you very much, and good luck to you, okay? I was going to call Sharon Scott. No, I saw the name, I was taking it. Okay, fine, perfect, thank you so much. All right, Lucille Gessling, please.
She's approaching Judge here at Maine. Come on up, Ms. Gessling.
Okay, good morning, Ms. Gessling. You're charged with count 1, fraudulent, utter a false instrument. Bond's been set at $1,000. Court does find probable cause. Bond is set at $1,000. Anybody wish to be heard with regard to bond or probable cause?
Not as to probable cause.
Judge, I'm going to be asking you to consider releasing our pretrial release. I'll see if the state has an objection.
I have no objection.
All right, ma'am, we're going to put you on pretrial release. She's going to be on standard pretrial release. Ma'am, is your address 8811 Northwest 14th Ave, Miami?
Yes.
All right, you're to have no victim contact, direct or indirect, with the alleged victim in this case with the initials SP. That means, and for everybody, I'd like you to listen up at the jail when I say no contact, direct or indirect, that means no contact in person, calling, texting, writing, or through third parties, and certainly nothing through social media. You understand, ma'am?
Do you understand?
All right, perfect, thank you. Put her on standard pretrial release
Give it to you right now. You have to go and report as soon as you're released, okay? Good luck.
within 24 hours or on Monday, if
Within
not
24
today.
hours. Okay? So if you get released early today, you go and report them before 3 o'clock. If you get released too late, it's Monday
Hello,
before
how are
noon,
you?
all right?
Do we have
Who did you
somebody?
call? Oh, Spanish interpreter?
No, I didn't call anybody. The Spanish interpreter walked in.
Yes, Judge, I was told we need a Spanish interpreter for someone in the main jail.
Okay,
Yes, Judge, the gentleman that's gonna require Spanish interpreter, I wrote it down right here. Mr. Juan Fuentes Espina, he is on page 12 of your document. Senor Fuentes Espina.
is there anybody else at the main jail?
Let me inquire, Judge.
Can you make an announcement? We'll see if anybody else.
No one else at me.
Thank you.
¿Alguien más requiere servicio de intérprete en español?
Okay, anybody at North Broward need a Spanish interpreter today?
¿Servicio para español?
Okay, no response from North Broward. Anybody at Conti?
No, ma'am.
Good morning, how are you?
Good morning.
All right, anybody at Paul Ryan?
All good, ma'am. Good morning.
Thank you, sir. All right, if you could raise your right hand.
Yes, Your
to
Honor.
Swear and or affirm to translate from Spanish to English, English to Spanish to the best of your ability, sir.
I do. Gabriel Sinisi, C-I-N-I-S-I.
Thank you.
You're welcome.
All right, are you Juan Miguel Fuentes Pimenta?
¿Es usted el señor Juan Miguel Fuentes Espimenta?
Sí.
Yes.
All right, sir, you are charged with 1 count of resisting an officer without violence.
Señor, está siendo acusado de un cargo de resistir a un oficial sin violencia.
The court does find probable cause.
El tribunal sí dictamina que existe motivo fundado para ello.
Bond is set at $100, sir.
La fianza es fijada en $100.
Can you make the $100 bond, or anybody want to be heard?
Puede,
Sure.
puede pagar la fianza de 100 si yo quiero ser escuchado, su señoría.
Go ahead, Mr. Romero.
Not as a probable cause, I didn't review the report, however, in reference to the bond, I'd be asking for your honor to consider an ROR. My understanding is this is, I'll let the translator.
No con respecto al motivo fundado, porque no he tenido tiempo para leer el expediente, pero con respecto a la fianza, le estaría peticionando a su señoría que lo suelte bajo palabra.
My understanding is this is his first arrest, this is a misdemeanor offense. He's 26 years old, been residing in our community for over 4 years now, Judge.
Yo entiendo que es su primer delito, es una falta de todas maneras, tiene 26 años de edad y ha estado residiendo en nuestra comunidad por 4 años.
Okay, the
He's
court,
a handyman by trade, he's self-employed, works for himself, and he supports him and his wife.
Es un handyman por cuenta propia, trabaja por cuenta propia y él mantiene a él y a su esposa.
When he was arrested, he didn't have his phone with him, and his phone, and his wife just obtained a new phone number, and he doesn't have that one memorized.
Cuando fue arrestado no tenía el número de teléfono, no tenía el teléfono con él y él, la esposa recién consiguió un teléfono nuevo y no tiene memorizado el número de teléfono de la esposa.
So based on this being a misdemeanor offense, his first contact with the system, I would feel this is reasonable to have him ask for an R warrant in the act.
Así que basado que es un delito menor o una falta y que es su primer contacto con la justicia, yo creo que es razonable peticionar que sea soltado bajo palabra.
Mr. Reedy, any objection? I just want to start from the top with two probable cause.
Señor Reedy, ¿alguna objeción?
No, Your Honor.
No,
Okay,
ninguna
the court
objeción.
does find probable cause.
Sí, también el tribunal que existe motivo fundado.
Mr. Linder?
Señor Linder,
I have no objection to an ROR.
no tengo objeción a que lo suelten bajo palabra.
I would ask, though, that the court order him not to have any return to the Walmart at 5555 West Atlantic Boulevard in Margate.
Yo no tengo ninguna objeción a que lo suelten bajo palabra, pero sí pediría que él no regrese al Walmart, que está ubicado en 5555 Oeste Atlantic Boulevard en Margate.
All right, sir, the court is going to release you on your own recognizance.
Bueno, señor, el tribunal sí lo va a soltar a usted bajo palabra.
You are not to return to the Walmart
No puede regresar al Walmart
at the 55545 West Atlantic Boulevard, Margate,
en la dirección de 5555 Oeste Atlantic Boulevard en Margate
during the pendency of this case.
durante el proceso, mientras que esté abierto el proceso este.
If you change your address from the 1180 Sussex Drive address,
I'm sorry, 1180?
Sussex, S-U-S-S-E-X, I'm sorry, Drive, address,
Si llegase a cambiar su dirección del 1180 Sussex Drive,
it's your responsibility to make sure that you notify the clerk of the court
es su responsabilidad que usted notifique al secretario del tribunal
in writing with your case number
por escrito y adjunte también el número de su caso
and your attorney.
y su abogado.
You'll be getting a notice, sir, in the next 7 to 10 days
En los próximos 7 a 10 días va a recibir notificación oficial.
with your court date. If not, you're going to have to contact your attorney or the public defender.
Lo va a recibir por correo y si no lo recibe va a tener que contactar a su abogado o al abogado público.
Or you can go online to the Broward Clerk of Court.
O podés revisarlo online con el secretario del tribunal en su sitio de internet.
Thank you.
Gracias.
Good luck,
Bueno, sir.
sir. Okay, anybody else at the main jail need a Spanish interpreter?
No, Judge.
All right, thank you so
You're
much.
welcome, Your Honor. Have a good day.
All right, hello. Which case are you here on? Jermaine White. Are we ready for that, Mr. Reedy?
There was, there she, okay. I believe we are, Judge, yes.
All right, let me find the case. It's
He's
Jermaine
on-
White on page 13, folks.
Right. Why don't you folks come on up?
Are you Jermaine White, sir?
Hello, how you doing?
Good, is your name Jermaine White?
Yes, ma'am.
All right, we have 4 people here for you today. All right. Mr. White, you are charged with count 1, aggravated battery with a deadly weapon. we need to talk about bond. Count 2 is battery caused bodily harm, bond set at $1,000. Any objection to probable cause?
No objection to probable cause, Judge. I think that does exist here.
Court does find probable cause. The court is going to order no victim contact, direct or indirect, with the alleged victim in this case with the initials KDR. Is that the only alleged? Hold on one moment. With KDR in this case. Direct or indirect, sir, I don't know if you heard me state it. It means no contact in person, through third parties, calling, texting, anything on social media, and no writing. Do you understand?
Yes.
Okay. All right.
Your Honor, before we take any testimony from the family, I just want to caution you folks, do not discuss the facts of the case. We're here to determine Mr. White's ties to the community, the support that he has, his likelihood to return to court, and what kind of financial situation you're in as far as what you might be able to post as a bond. But we're not here to go into the facts of the case this morning.
All right. Good morning. Can you all state your name and who's present and spell your last name for the record, for the court reporter?
Edo White, I'm his mother.
Good morning.
Akeem White, I'm his brother.
Okay.
Destiny White, I'm his daughter.
Okay. Good morning.
Kenesha Douglas, my son's father, well, mother.
Okay. All right. So I'll give you an opportunity if you want to tell me anything, or if you just want to be here for support and not say anything, that's fine as well. So, State, let's talk about bond on count 1 and any other conditions or restrictions you would like to see.
I'm going to be requesting a $10,000 bond, Your Honor. First, based on the level of violence, it appears there were independent witnesses. The officer investigated, determined Mr. White, based on the allegations, initiated the incident, and at one point choked the alleged victim with a wooden plank, placing it against her throat. Your Honor, I would also note Mr. White's criminal history: 2009, possession of cannabis; 2008, unlawful use of false name ID; 2005, domestic violence battery, criminal mischief; 2002, possession of cocaine, resisting without violence with a violation of probation. I also see a prior failure to appear.
Okay, defense?
Judge, I would just in comment on Mr. White's prior record, it appears he hasn't had any contact with the criminal justice system in quite some time. And I don't know what happened here. I know it's a dispute amongst people who know each other. I'm sure Mr. White is looking forward to his day in court. And while there is probable cause, I think there's probably more here than meets the eye.
Okay, defense, Mr. Romero?
Yes, Judge. And speaking of Mr. White, he's been residing here in South Florida his whole entire life. He is 34 years old. He is working. He obtained employment with the Hilton Hotel. He's been there for about 8 months now. He's a dishwasher, and he's been there, I believe, he's making about $9 an hour. He lives in Fort Lauderdale with his mother. He's been there for about 1 year. And Judge, at this time, Mr. White, financially, he has no sort of income to help post his monetary bond. He's going to be relying solely on his family. So, Judge, I don't know if you wish to inquire with his family as far as how much they can potentially afford on Mr. White's behalf.
All right, I noticed here it has for the apartment number 1, and then it has number 10. And one of them says Lauderdale Lakes, and the other one says Fort Lauderdale. Lauderdale. Can you verify your address with me, sir?
What's the apartment number?
We can hear you.
Oh, sorry. Judge, in reference to the apartment, I believe it's apartment number 1, and he believes it's Lauderdale Lakes.
4122 Northwest 41st Ave.
Yes. Yes, Judge.
39th Avenue.
It's 30, okay. Let me just have the clerk update the address, because it's very important that he get notice.
Hey, I need to get a from the second.
Okay, if you could give me his address, ma'am, thank you.
4122 Northwest 39th Avenue, Lauderdale Lakes. Oh, I'm sorry. I'm so
No,
sorry.
that's fine.
It's no apartment.
Okay.
It's a
4122
duplex.
Northwest 39th Ave.
Lauderdale Lakes 33309.
3330.
Yes.
All right. Anything further?
Well, I don't know what situation the family is in from a financial perspective. How much money do you think you folks might be able to come up with to bond him out? You'd be able to make a $5,000 bond? Judge, I'd ask for a $5,000 bond. He has obviously strong ties to the community. This is somewhat of a domestic incident. And he has obviously very strong support and ties to the community. He has had the same job for 8 months, so he is not a likely flight risk, and will be coming to court. Any other conditions of pretrial release that the court feels are appropriate, I'm sure Mr. White would be in agreement with.
Is there anything you need any further would like to tell me, tell the court?
What I wanted to say,
If you could move over, sir, because it's recording.
what I wanted to say was, what he spoke on earlier, so that stopped me from being able to say what I wanted to say, which was go into the case because I was on the scene. So I just wanted to state that, you know, it was, I ain't gonna say a misunderstanding. I was there and I spoke with the police officer and I asked him, I don't understand why y'all arrested him and charging him with that when he was attacked. And as far as what he spoke on, the wooden plank, she attacked him with that.
Right, let's not get into the facts of the case at this point. I know, I understand, I know.
Speak, but I just felt like that should be known. I was there. I spoke to the police. Like I said, he took it from her, but they charged him as if he attacked her with that. So I don't have nothing else to say. I mean, well, yeah, I'm his supervisor at work. So, but that ain't got nothing to do with what we talking about now.
The fact that he'll make it to court.
Oh yeah, he gonna come to court.
Okay, the court's gonna order, sir, no victim contact, direct or indirect, KBR. Court is gonna set a bond on count 1 at $6,000, and on count 2, the battery caused bodily harm at $1,000. So it's gonna be a $7,000 total bond, okay?
Judge, we'd also ask you to sign an order allowing us to photograph Mr. White's injuries that he sustained.
Sure, granted.
Thank you, Judge.
Thank you and good luck to you. Okay?
Thank you.
Sandy, Adrian, please. Sandy, Adrian, please. Paul Ryan. Okay. Good afternoon, good morning. Are you Sandy Adrian?
Yes.
All right, ma'am, you have driving while license is suspended, third or subsequent offense, $750 bond. And then you have attaching a registration license plate not assigned. It's basically an ROR. The court does find probable cause. Anybody want to be heard with regard to the $750 bond?
Your Honor, I don't know if Miss Adrian can make that bond. Miss Adrian, can you make a $750 bond?
That's kind of too much. Because I don't have money like that.
Judge, I'd ask you to consider pretrial release or ROR on Miss Adrian if we can establish her address and if her prior record is not inconsistent with the court making a ruling in that regard.
I'm sorry, you said you wanted what?
ROR, pretrial release.
All right, ma'am, is your address 1337 South Dixie Highway?
Yes.
Okay, it doesn't have has apartment number on one, is it 508?
508.
Deerfield, right?
Yes.
All right, state, any objection to standard pretrial?
Yes, Your Honor, I could understand the court reducing the bond. I think some bond is appropriate. Ms. Adrian has a combination of 6 prior either DWLSs or operating without a valid DL. One of her prior DWLSs was with a leaving the scene of an accident.
bond?
I'm sorry?
Can you afford to post any bond?
I think the most that my brother probably can come up with is 500.
Judge McHugh,
Because he works at McDonald's. He doesn't make as much.
10 o'clock, I guess.
All right, this is what the court's gonna do. The court's gonna ROR her and put her on standard pretrial release.
Jason.
Hey, ma'am, you're charged with a felony. So, with this driving while license is suspended, I'm gonna put you, instead of, just outright releasing you, I'm gonna put you on standard pretrial release, which just means you have to, within 24 hours of your release, you have to show up at the pretrial office. Deputy Paul Ryan, would you be kind enough to give Miss Adrian a map to pretrial services? Okay, thank you. All right, so, okay, let me just tell you what you have to do so you understand. You have to report within 24 hours of your release. However, they're closed on the weekends. So the latest you can get there today is 3 o'clock. If not, you have to show up by Monday by 12 noon. If you don't show up, there's gonna be a warrant for your arrest and you're gonna be back here again. And if you don't show up for court or drive again, or anything happens and you get arrested, you could violate your pretrial release. Then you could be held no bond. So, you know, it's like a snowball effect. It just keeps going. So no more driving until your license is cleared up and standard pretrial release. You are gonna have to call in twice a week and report once a month, okay?
Okay.
All right, good luck to you, ma'am. Sure.
I have a question. You said I have to do it by 3 o'clock today?
If you get released in time.
What I meant is if you get released by 2 o'clock, you have to, you know, before 3 o'clock, then go over to pretrial services.
Okay, so go straight there?
Yes, but if it's 3 o'clock or after that, then you can go, but you have to go by Monday, okay?
Okay, thank you so much.
Because they're closed on the weekend, so, all right?
Thank you, Judge. Good luck, Miss Adrian.
Thank you. Letitia Smith, please.
Bond posted.
Ms. Smith? Oh, bond been posted? Okay.
Okay, is Letitia Smith there? Was she
Yes,
there?
she is, Judge. I mean,
All right, I just want to confirm her address. Is it 311 Bishop Road?
Yes.
All right, thank you very much, ma'am. All right, Arian McNair, please. Is it,
she's here present, Judge?
okay, is your middle name Anna Salisa?
Yes.
Okay. All right, ma'am, you have count 1, obstruction of criminal investigation, false info to Leo, missing person. There's no bond attached to that, which is essentially ROR. Count 2 is possession of cannabis, 20 grams or less, $100 bond. You do have a probation violation or community control where you're gonna be held no bond. Does anybody know when her next court date is?
She's out of probation Dade County. I'd actually consider RO on top too.
Oh, it is Dade County, okay.
It's Marion County.
Marion County. All right, so what the court's gonna do is the court will find probable cause. The court will ROR you, ma'am, on count 2. All right? Good luck to you.
Good luck, ma'am.
Next one is gonna be Attila Angel Kennedy. Okay, thank you.
Medical research, madam.
Medical reset, okay. Good morning. Chandra Marie Posey, please. Sandra Marie Posey, please.
Yes, ma'am.
Paul Ryan? Okay. I left that over there, it's still convenient. Hello, ma'am, are you Chandra Marie Posey?
Yes, ma'am.
All right, ma'am, you're charged with 1 count, possession of heroin, $1,000 bond. Count 2, possession of cocaine, $1,000 bond. Count 3, driving while license is suspended. Habitual, it's being charged as a felony. And count 4, drug paraphernalia possess and or use, which is basically a possession of drug paraphernalia, $100 bond. Any objection to probable cause?
No, Your Honor.
Court does find probable cause. Does anybody want to be heard with regard to the $1,850 in bond?
You going to be able to make that bond, Ms. Posey?
Yes.
Okay.
How do you know that, ma'am? Did you call somebody?
I called somebody and I called the bondsman and they'll do the 10% with the signature. I actually have the money here in property with me.
Okay, let's
I'm
do
just-
an order then, allowing her to access her property for purposes of bond. I'm glad you told me that, ma'am. All right.
Thank you, ma'am.
Can I just verify your address? I have two different addresses here. I have one in Arizona and the other one in Lauderhill.
Lauderhill is where I'm staying. I'm actually my friend's caregiver because he's paralyzed, so I've been his in-home healthcare
All right, so
provider.
don't get into any of that. Let me just ask
No,
you
I'm just
this.
saying, the 5701 South 27th Court.
It says
is the address-
northwest. It says,
Northwest, that's it. That's the address where I'll be residing.
all right. If you change that address, ma'am, you have to notify the clerk of the court immediately in writing, because
Yes.
it's your responsibility if you don't get a court date notice and you change your address and don't notify the clerk and your attorney in writing with the case number, then what will happen is you'll miss a court date and then there'll be a warrant for your arrest. You can also go to browardclerk.org and put in your name and see when your next court date is. So
Okay.
your address I have, and if it's not this one, just make sure you update it, 5701 Northwest 27th Court. There's no apartment number attached to that?
No, ma'am. It's a duplex.
Okay, Lauderhill,
Yes. 33313.
I have it. All right, ma'am, thank you very much.
So I have a question. What does that mean by I can access my funds to be bonded? I don't.
You said you had money in your property
Yeah,
at the
I have
jail?
money on my books here.
Okay,
So that means that I can call a bondsman and like I don't know what that
do you
means.
want to tell her what that means, Mr. Reedy? Okay, the phone's gonna ring to your right, ma'am, okay?
All right, thank you.
To your right. Pick it up. Thank you, Mr. Reedy. All right, Alexandria Corrine Santiago.
I don't even know when I did that paper.
That's
No,
still
it
a
is a
medical
reset. I don't know what the paperwork is.
loan? Are you Alexandria Corrine Santiago?
Yes.
Okay, all right, give us just one moment, ma'am. Thank you, Mr. Reedy. All right, Ms. Santiago, you have a capious misdemeanor on no bond hold, and then you have two out-of-county holds also being held no bonds. All right, so it's out of Judge Zeller's division, the first one, and then the other two. All right, ma'am, you're gonna be held no bond. Does anybody know when she's going before Judge Zeller?
Judge, she'd like to work out the misdemeanor charge today so that Dade County can come and get her. We had Miss Santiago on our docket yesterday, but she was in family court at the time, and we reset her for the afternoon, but we weren't able to get her back here in time to have a hearing on this. But I have spoken to her, and she is desirous of resolving this 2013 misdemeanor.
Okay, Judge Zeller doesn't want me working out her cases, so I could just ask your office to contact Judge Zeller's office. Maybe you can get her on the docket. Thank you. Next one, thank you, ma'am. Contact the public defender, they'll try to get you in court earlier. Charles Michael Squillis, please.
Is this ammo?
Sierra Main Judge, Municipal Ordinance.
All right, thank you very much. Mr. Squillis, good morning,
Yes,
sir.
ma'am.
You have a no-show at arraignment of capious for $100. It says enter city park prohibited.
Yes.
And then you have another one, trespass private property.
Okay.
They're both municipal ordinances. Would you like to resolve your cases today for an adjudication time served? Or would you like to have a trial and dispute the charges?
No, I'd like to resolve it today, please.
All right, raise your right hand, sir. Do you swear and/or affirm to tell the truth?
Yes, ma'am.
Okay, is your name Charles Michael Squillace, Squillace?
Yes, ma'am.
Is anybody forcing you to resolve your case today?
No, ma'am.
It's my understanding you wish to waive your right to an attorney and trial, sir, in these two cases?
Okay, just make sure to mention.
You want to give up your right to a trial and plead guilty or no contest? Let me explain it to you this way. Do you want a trial or you want to admit to the charge today?
No contest will be fine.
All right, so you don't want a trial. You want to give up that right to have a trial and plead no contest today.
Yes, ma'am.
Are you under the influence of any drugs or alcohol?
No, ma'am.
Ever been treated for a mental illness?
No, ma'am.
Okay, you're going to plead guilty, not guilty, or no contest to entering a city park and trespass private property.
No contest.
Okay, the court's going to accept your plea, find that's freely and voluntarily given. The court has reviewed the court file and finds probable cause for the plea. The court is going to adjudicate you and time serve you on each count. The court is going to impose on each case $78 in court costs, sir. You have 30 days to appeal the sentence of the court. If you can't afford an attorney, one will be appointed. You're done with these cases, sir, except for paying the $78 in court costs in case 1 and 2, okay? Good luck to you, sir. You'll probably be released today. Thank you.
Thank you. Thank you.
You're welcome. Kevin Pierre, please. Kevin Pierre, please.
He's approaching. There's a here, ma'am.
All right, good morning, Mr. Pierre. You have count 1, expired motor vehicle registration. Over 6 months, first offense. It's actually not for magistrate court. Count 2 is a capious traffic, driving while license is suspended. Bond is set at $500. Court does find probable cause. Anybody wish to be heard?
Judge, Mr. Pierre asked me to ask for if you would consider resolving the case today for withhold, take judicial notice of time served in exchange for his no contest plea on count 1. I believe it's an infraction to dismiss the infraction, Judge.
All right, state.
That would be the state's offer.
Sir, raise your right hand for me, please. Do you swear and/or affirm to tell the truth?
Yes.
Is your name Kevin Pierre, Pierre?
Yes.
All right, you can put your hand down. It's my understanding you wish to waive your right to a trial, sir.
Yes, it is.
Anybody forcing you to do this?
No, Your Honor.
Are you under the influence of any alcohol, drugs, or medication?
No,
Ever been treated for a mental illness?
no.
You understand that if you're not a U.S. citizen, a plea of his charge could result in deportation proceedings and affect your ability.
Yes, I understand.
Okay. All right, you also understand that if you get 3 driving while license suspension convictions within a 5-year period, sir, the driver's license bureaus can revoke your license for 5 years as a habitual traffic offender. Do you understand that?
Yes, I understand.
And understanding what I just explained to you, you pleading guilty, not guilty, or no contest to driving while license is suspended, sir.
No contest.
Okay, and you don't want to plead no contest just to get out of jail. Is that correct? In other words,
yes.
if I are, do you want to fight these? Are you just admitting to the charge today because you can't pay the $500 bond? You want to speak to him, Mr. Romero?
Yes, sir.
Thank you. Oh, sorry about that. There you go. Okay. All right, sir, I just want to make sure that you're not resolving this case today because you can't bond out of jail on the $500.
No, that's not the case.
Okay, all right, that's fine. So, sir, you want to plead no contest, you said, to driving while license is suspended, right?
Yes.
All right, the court is going to accept your plea, find that's freely and voluntarily entered. The court has reviewed the court file and finds probable cause for the plea. The court's going to withhold adjudication and impose court costs, sir, of $293. The court will take judicial notice of time served. You have 30 days to appeal the sentence to the court. If you can't afford an attorney, one will be appointed. The court is going to dismiss the civil traffic infraction. Trying to look for some identification number for it, which is citation number A9SXXFE. Okay, thank you very much, sir. Good luck to you.
Good luck.
Madam Clerk, it's on the police report, the citation number, okay? Adam Matthew Sponsel, please.
Come on up, Mr. Sponsel.
Good morning, Mr. Sponsel. You have resisting an officer without violence, $100 bond. Count 2 is petty theft, second degree, first offense. No bond attached to it. The court does find probable cause. Court is going to order no return to the Walmart at 5001 North Federal Highway in Pompano Beach, Florida. Do you understand, sir?
Yes, Your Honor.
All right. Anybody want to be heard?
Judge, I think Mr. Sponsel, he wishes to resolve the case today for time served.
State.
One moment, Judge. I have no objection.
Okay, did you explain, Mr. Romero, to Mr. Sponsel that if he gets another theft charge, it can be charged as a felony, even though it's a petty theft?
I just explained it to him right now.
All right, thank you. All right, Mr. Sponsel, raise your right hand. Do you swear and/or affirm to tell the truth, sir?
Yes, Your Honor.
All right, put your hand down, please. It's my understanding you wish to waive your right to a trial, sir?
Yes, Your Honor.
And you spell your last name Sponsel?
Yes.
Is anyone forcing you to do this?
No.
Are you under the influence of any alcohol or drugs?
No.
Ever been treated for a mental illness?
No.
You understand that if you're not a U.S. citizen, a plea to discharge could result in deportation proceedings, sir?
Yes, Your Honor.
And you understand also that if you get another theft charge, it could be charged as a felony. Do you understand that?
Yes, Your Honor.
Understanding what I just explained to you, you pleading guilty, not guilty, or no contest, sir, to resisting an officer without violence, count 1, and count 2, petty theft, second degree, first offense.
What do you think? Are you pleading not guilty, guilty, or no contest in this case? Well, if you want to resolve your case, it would be either guilty or no contest. By submission, it would be no contest. No contest. No contest, Your Honor.
Okay, the court is going to accept your plea, find that it's freely and voluntarily entered. The court has reviewed the court file and finds probable cause for the plea. The court's going to order no return, sir, to the Walmart, 5001 North Federal Highway, Pompano Beach. The court is going to adjudicate you and time serve you on each count. The court is going to impose court costs on count 1 of $293. You have 30 days to appeal the sentence to the court, sir. If you can't afford an attorney, one will be appointed. Please don't return to the Walmart, sir. You're not allowed there, okay? Thank you.
I understand.
Good
Yes,
luck to
Your
you.
Honor, thank you.
You're welcome. Richard Joseph Masswing?
Robinson, you have no bond on the card.
Don't worry about it.
Print that out.
Sir, how do you say your last name? Oh, thank you.
McEwing.
McEwing, okay. All right, Mr. McEwing, you have obstruction of highway. Says here, court does find probable cause. Does say here that you are habitually nuisance that area. and that you've been offered homeless outreach program. What are we doing with this case, folks? $125 bond.
Judge, she's homeless, this is a panhandling charge. Just asking Your Honor if you would consider resolving it for time served.
State?
It's fine.
Okay, is he gonna return to that area?
Can't go back to that place, okay?
I think I've told him before not to go back to that area. Can you pull up his name?
It's not really identified. It's lateral. It's still PBL. We just don't have to prove it first. Okay.
Oh, thank you. All right, sir, raise your right hand. Do you swear and or affirm to tell the truth? All right, is your name Richard Joseph McEwing, M-C-E-W-I-N-G, sir?
Yes.
You can put your hand down. It's my understanding you wish to waive your right to a trial.
Yes.
Anybody forcing you to do this?
No.
Are you under the influence of any drugs, alcohol, or medication?
No.
Ever been treated for a mental illness?
No.
You want to plead guilty, not guilty, or no contest to obstruction of highway?
A contest.
You understand, sir, that you can't go back to this I-95 off-ramp in West Atlantic Boulevard?
Yes.
Okay, and you're going to plead guilty, not guilty, or no contest? No
No
contest?
contest.
Okay. All right, the court's going to accept your plea. Find that's freely and voluntarily entered. The court has reviewed the court file and finds probable cause for the plea. Court's going to adjudicate you and time serve you. Impose court costs of $293, sir. You have 30 days to appeal the sentence of the court. If you can't afford an attorney, one will be appointed. Good luck to you, sir. No return to the off-ramp.
Thank you.
You're welcome. Let me know when you're ready, Mr. McLawrence. Jim Kendall Alsanot, please.
Mr. Alphenot, for present.
Who's this?
Next one should be Parker.
Oh, yeah.
I guess we skipped over Nairn. I didn't know.
Joseph Billy, please.
I guess not. But whatever.
You have it? Oh.
No, I had Parker here.
Okay, are you Mr. Jim Alsanot, sir?
Yes.
All right, sir, you are charged with you have a municipal ordinance, or two of them actually. One is for an open container, the other one is trespass private property. Court does find probable cause. Bond set at $25 and $100. You want to resolve your case today, or you want to come back and fight your court case, sir?
I do want to resolve the case, right, Judge, but I want clear understanding about the trespassing charge.
That's a 2016 case.
Can you pull this
Because I
up,
believe it
16?
was 2016 case.
Yes, it is, sir, a 2016 case right here.
And I wanted more information because, Your Honor, all last year.
Well, don't talk about the facts of your case, because everything's being recorded.
That case though, but I've been in front of judges several times last year and this year, and you know this warrant just it didn't pop up then, but you know all of a sudden I got pulled over by police and he was looking for proper cause to put me in jail. He charged me with a trespassing for ever since 2016, and it don't make no sense because I've been in front of the judge all year, last year and this year. No warrant popped up then. Where it came from, y'all? 2 years old warrant.
Okay, let me tell you what it is, sir, okay?
Okay.
Says that on July 27, 2016, you were at 2030 Coolidge Street, which I believe is in Hollywood, Florida. back in September of 2000, well, actually, you were set for a non-jury trial
Right.
in September, and you failed to appear, so they issued a warrant for your arrest.
Your Honor, if I'm not mistaken, the judge, she dismissed that charges there. She dismissed it, if I'm not mistaken, Your Honor.
No.
And matter
So
of fact,
this
she
is
did.
what we can do, sir. If you want, we can resolve your cases today, or if you want, I can ROR you and you can come back to court and fight the charges. Up to you.
I would love the ROR, please.
All right, so court's gonna ROR you, but I need to know, where are we gonna mail notice, sir?
2020 Scott Street.
Okay. All right, sir, you're gonna get arrested again and again and again. You gotta resolve these cases, okay?
No, I will. So I'll be released today, Your Honor.
You'll be released today if you have nothing else pending.
Okay, thank you. Have a great one.
You too, thank you. Daniel Ray Parker, please. Hello, Mr. Parker.
Good morning.
Good morning. You have one count, resisting an officer without violence, $100 bond. Count 2 is trespass property, not a structure or conveyance. No bond attached, which is basically an ROR. And then you have a municipal ordinance, an open container. I believe is a Hollywood municipal ordinance. So, court's gonna find probable cause, $100 bond total. Anybody wanna be heard?
Just one moment. I'm seeing Mr. Parker as far as one issue.
Are you ready, Mr. McLawrence? Sure, just let me know when you're ready. I saw you standing there, I didn't know if you were waiting. Cool.
All the matters that are here before you, Judge.
All right, state what's your offer on 1 and 2, please?
State's offered be an adjudication, time served, no return.
Seventh of March. The
What?
charge at that time was a battery on a person over 65 years of age or older.
Can
He
you
was placed,
hear her, Mr. Romero?
Yes, yes.
he was placed on pretrial by Judge Bidwell.
So we are not resolving the cases today. So this is what the court's gonna do. Did he bond out with Judge Bidwell? Was there any bond attached to that?
I do not know. I have a court order here that says defense motion to ROR bond is granted. Standard pretrial calling 3 times a week. So it does not appear
Okay, can he
that.
afford the $100 bond?
Trace, you search fine,
Well, no, you can't resolve it. Judge, he informed me he can't,
same first name.
for to post the bond, he wishes to resolve it, but I informed him, the court's not gonna resolve it at this time. Judge, would you consider releasing him on pretrial release on this case as well?
I've been corrected by the state. It was Judge Fine that placed him on pretrial, not Judge Bidwell.
Sorry,
It was Judge Fine that placed him on pretrial, not Judge Bidwell.
Judge Fine put him on free trial, not Judge Bidwell.
Okay.
All right, so the court's gonna ROR standard pretrial release. Sir, it's your responsibility, I know you're using the 2020 address. If you don't get notice in the mail, for you to go to a public library and look up for when your court date notices are in all your cases, okay? Because you have your municipal ordinance case, and then you have the other misdemeanor cases, and now you have the felony case, okay?
Right.
All right, good luck to you, sir.
Your Honor, on this court order, it
Hold
said
on
that,
one moment.
it did say that the defendant must call in at least 3 times per week. Is that what the court wants me to?
Yes, I'm gonna still have him call in, so he wouldn't call in, he'd just call in one time for all cases, correct?
No,
How
he's
does that
calling
work?
in 3 times. He has to make calling in 3 times. He's going to have the same person that's supervising him. So that person will have all of his cases, and he must make contact with them 3 days per week.
All right, sir, you're gonna have to also, thank you. You're also gonna have to check in with pretrial release. If you get out today before 3 p.m., if not, by Monday, 12 noon, you understand?
Yes, ma'am.
24 hours. Thank you, sir. Good luck to you.
Thank you. So as soon as you get out, go to pretrial.
Your Honor, North Broward has asked if we could call a case out of turn.
Sure, no problem.
It's a Jean-Paul Valbrun. He's on page 21. We are on page 11.
All right, so I'll let Michelle look that up just so we can keep moving along. And we'll just take the next one and then we'll take it. Xavier Fitzgerald. Fitzgerald Jones, please. Hello, sir. How are you? Are you Mr. Fitzgerald?
Yes, it's Mr. Fitzgerald.
All right, sir. You have a capious misdemeanor. This is a 2014 driving while license is suspended. $500 bond. What are we doing with this case, folks?
Judge, he wishes to resolve this case today.
Okay, state.
One moment.
What's the next one? I don't know where this case is. Hold on, sir. The state's getting a plea offer, okay?
State's offer would be a time served. It appears this would be a second within 5.
All right, this is his second appears, Mr. Linder said, in 5. Did you speak to him about 3 convictions within 5 years?
I will right now, Judge.
Thank you.
Yes, Judge, I still wishes to go forward.
All right, sir, raise your right hand. Do you swear and/or affirm to tell the truth?
Yes, ma'am.
All right, your name is Xavier Fitzgerald Jones, Jones.
Yes, ma'am.
It's my understanding you wish to waive your right to a trial, sir?
Yes, ma'am.
Anybody forcing you to do this?
No, ma'am.
Are you under the influence of any alcohol, drugs, or medication?
No, ma'am.
Ever been treated for a mental illness?
No, ma'am.
You understand that if you're not a U.S. citizen, a plea to discharge could result in deportation proceedings and
Yes,
affect your
ma'am.
ability to remain in the United States?
I hear you say what?
And affect your ability to remain in the United States?
Yes, ma'am.
All right. With regard to the driving while license is suspended, if you get 3 convictions, and my understanding is this is your second in 3, if you get 3 convictions within 5 years, driver's license bureau is going to revoke your license for 5 years as a habitual traffic offender. Now, understanding that, you still want to go forward and plead guilty or no contest to driving while license is suspended.
I want to plead no contest.
Court's going to accept your plea, find that it's freely and voluntarily entered. The court has reviewed the court file and finds probable cause for the plea. Court's going to adjudicate you, time serve you, and impose court costs, which are required to by law of $293. You have 30 days to appeal the sentence of the court. If you can't afford an attorney, sir, one will be appointed. Good luck to you, sir. You're done with this case, except for paying your $293. Thank you. Okay, let's take what North Broward, 1 case at a turn. Jean-Paul Valbrun. Sorry, you said what page is this?
He's on page 21, Your Honor.
Okay. Hello, are you Mr. Jean-Paul Valbrun, sir? All right, sir, you have count 1, possession of burglary tools with intent to use, $1,000 bond. You also have burglary of an unoccupied conveyance unarmed. We need to talk about bond. Court does find probable cause. State?
Your Honor, I'd be requesting a $3,500 bond on count 2. Mr. Valbrun in 2015 had a charge of assault on a person over the age of 65 and criminal mischief dismissed on competency grounds. 2014, he was convicted of robbery by sudden snatching. 2009, he was convicted of battery on a law enforcement officer, resisting without violence, and unlawful use of false name ID. End of record.
find it. Was this the one where he was looking in the window of a residence?
No, no, this involved, one moment.
Here it is, it's on the top of page 2.
The person observed, the victim observed him trying to get into her vehicle.
As advised, the culprit was now being seen looking into the window of a residence in the area.
I apologize, I got it. No, yeah, I got it confused.
My memory. Okay, defense?
I'd ask for a $1,000 bond, Judge.
Okay, is his address 1240 Southwest 30th Ave?
I don't know.
Sir, is your address 1240 Southwest 30th Avenue?
It's Walmart. Literally.
And I think this is an,
Inquire how long he's lived here, because it says 0 months and he's from the Bahamas, so. Don't, hold on, sir, you have an attorney representing you.
Mr. Valbrun, how long have you been living in South Florida?
50 years, sir.
I think count 2 is actually an attempt, Judge. And who do you live with, Mr. Valbrun?
I was living at the house all the time, and I just went to go get a cigarette, and then somebody had a few words with me, and they went to lie to the police about me. Because I asked them for nothing. I said, why am I standing by the car with a stick? I was holding a stick to squeeze my shoulder in place. With like the garbage, and it just went really loud.
Your Honor, I'd ask the court to set a $1,000 bond on count 2, make a finding that it's an attempted burglary of a conveyance.
I mean, I didn't touch that car. I didn't look at that car. I was standing in front of the store all the time. That fool, bro. Because they see, I don't like mine, and he got my face, I'm running before the wall.
Okay, state, any, special conditions? I have no return to 3025 Davie Boulevard.
Well, I'd ask for that and no contact with JL. I don't know if the court's inclined to order an evaluation.
And your recommendation is the date?
I'm sorry?
That's what happened, how many days? Or you have to say how many days?
It would object to the court ordering an evaluation. Mr. Valbrun is our client. We'll take care of it.
And I believe if the court has a concern for the safety community or Mr. Valbrun, you can order it. Your Honor, if I could inquire from pretrial how long it's usually, if I may inquire, thank you.
No problem. All right, sir, the court is going to order no return to the 3025 Davie Boulevard and no contact, sir. Court's going to order no return to 3025 Davie Boulevard address and no contact with direct or indirect with the alleged victim in the case with the initials JL. And that means, sir, I don't want you calling, texting, going in person, writing, anything on social media, and no contact, direct or indirect, also means through third parties with the alleged victim with the initials JL.
Your Honor, state would be requesting within 5 days of release,
What, within 5 days of release?
the evaluation. Mental health
And if he's not released?
Then there's not an evaluation.
All right, anything further from
Yes, Your
anybody?
Honor. If the court's going to order an evaluation over our objection, then we are going to insist that that order include that that evaluation not take place unless Mr. Valjane's Assistant Public Defender is present.
Okay, your position on that?
Your Honor, as long as the public defender's office can set that up, I mean, it's gonna be on them then, just to coordinate with Mr. Valbrun within 5 days of his release then.
Well, I'm assuming Mr. Valbrun is not going to be released. And we don't want anyone talking to our client about matters that might bear on confidential information or the facts of this case. So we insist that, this is why we're objecting, because this is something that, in our opinion, outsiders should not be having contact with our client without notice to us. And since we are now appointed to represent Mr. Valbrun, any doctor, psychiatrist, any other court-appointed or state-appointed representative, police officer, anyone who has contact with Mr. Valbrun has to notify our office as to when that is going to take place and make arrangements that are mutually agreeable, not on the public defender's office, but mutually agreeable for that evaluation to take place.
Okay, this is what the court's gonna do, $1,000 bond on one, 1,000 on two, no return to the 3025 Davie Boulevard address, no contact direct or indirect with JL. Court does want a psych eval within 10 days of his release. Pretrial services can notify the public defender. That should be ample time for your office to have someone respond. Court does have a concern for the community, and based on the totality of the circumstances, that's the court's ruling. Thank you very much. Good luck. Dean Herman Alexander, please. Oh, I'm sorry.
That's all right.
Sure, we'll go side. So let's get to Mr. McLawrence's case. Thank you for waiting, Mr. McLawrence.
Thank you, Judge.
If I could call Paula Amanda Raquel, R-A-C-L-E, Raquel.
She's there at North Broward, Your Honor,
All right,
and she's on page 2 of the docket.
thank you. Hello.
Good morning, Your Honor.
Okay, are you Paula Amanda, you say Raquel? Raquel, thank you. All right, ma'am, you are charged with 2 municipal ordinances. You do have a court date, April 18th at 10 a.m. Your bonds have been set at $25 each. The charges are panhandling and solicitation or display on public right-of-way. Court does find probable cause. Mr. McLawrence.
Judge, as you noted, both counts are for panhandling.
Yes.
The first count is a Hollywood municipal ordinance, and the second count is a City of Fort Lauderdale municipal ordinance.
Okay.
And Ms. Rico expressed a desire to resolve these matters, Your Honor.
Okay. All right. Well, thank you for standing in for the Hollywood one. I appreciate it. Okay, ma'am, if you could raise your right hand. Do you swear and/or affirm to tell the truth?
Yes, ma'am.
All right. State your first and last name.
Paula Ray Cole.
R-A-C-L-E?
Yes, ma'am.
All right. Your attorneys indicated to me that you wish to waive your right to a trial in your case.
Yes, ma'am.
Okay. And you wish to waive your right to an attorney and trial in the other municipal ordinance in the Hollywood case?
Ma'am, I just want to resolve it and get out today, please.
I will, but I have to ask you certain questions, ma'am, okay?
Yes, ma'am.
To make sure you understand that you have certain rights and that you're giving up their rights and you're pleading guilty or no contest. So let me just ask you these questions. Do you want to give up your right to an attorney, to have an attorney represent you in this panhandling case, in one of them?
I want to do what the federal recommended, no contest.
Right, so can you stand in on the Hollywood case?
Sure, Judge.
All right, thank you.
Yes, ma'am.
All right, so you want to give up your right, you don't want a trial, you want to plead no contest, correct?
Isn't that what my attorney advised me to do?
Yes, Ms. Rakel, you expressed a desire to resolve it, so, and in order for you to resolve it, you'd have to plead no contest to resolve it.
Yes, ma'am. Yes, sir. No contest on both charges. I won't panhandle again, ma'am.
All right, are you under the influence of any drugs or alcohol?
Not at this time, ma'am, no.
Well, that's good. All right, have you ever been treated for a mental illness, ma'am?
Yes, ma'am.
Does your don't tell me what it is. Does your mental illness affect your ability to understand what's going on here today?
No, I'm just tired and hungry.
All right. Listen to my question, ma'am. Does your mental illness affect your ability to understand that you're going to admit and plead guilty or no contest to these charges of panhandling? Do you understand
Where's my
what's...
attorney recommending?
Ms. Rakel, the judge is asking you if you understand, like, okay, the judge asked you if you had a mental health history. You said yes, right? So the judge is asking you, does that prevent you from going forward with resolving your case here today?
No.
Okay.
No. No, it doesn't, ma'am.
All right, you want to plead guilty, not guilty, or no contest to panhandling, 2 counts.
No contest, please.
And you agree you're not going to go back to the area where these alleged incidents occurred?
I promise I'm getting out of Hollywood, I swear.
All right. The court's going to accept her plea, find that's freely and voluntarily entered. The court has reviewed the court file, finds probable cause for the plea. Court's going to withhold adjudication and impose court costs of $78 in each case.
Yes, ma'am.
Judge, I know you can't order this, but I'm not sure if you could possibly ask the deputy there at North Broward if there's the possibility that she could get some food before she is released.
Okay, ma'am, you know, there's a release desk when you're released.
Yeah.
You can speak to a gentleman by the name of Bob, and he'll tell you about alternatives available for you or options available for you to go get an evaluation and to help you out. You understand?
Yeah, I just want to get out of Hollywood and not cause any more problems to police.
All right. When you get released, speak to a gentleman by the name of Bob. Can you remember that?
Thank you. Thank you both.
All right, deputy at North Broward. Is there any way we can get Ms. Rackle some food before she's released?
Yes.
All right, thank you.
Thank you.
All right, so, hold on. So it's a withhold and court cost on each one, $78 court costs on each one, on 1 and 2. And then the court, hold on, the court does take judicial notice of the time that Ms. Rackle has served in the Broward County Jail. She has 30 days to appeal the sentence of the court. If she can't afford an attorney, one will be appointed. Yes, ma'am, thank you. What would you like to say? Yeah.
She was asking about a payment plan, Judge. So yes, Ms. Rakel, you can go to the clerk's office and you could discuss that with them.
I'll give her 6 months to pay.
Hollywood or Fort Lauderdale? That's a Hollywood, right?
It's actually here in Fort Lauderdale.
Right, at the city hall, across from Publix.
Yes.
I'll just go ahead and pay it, man. I don't want no warrants, please.
Okay, thank you. Take care. Get something to eat.
God bless you both. Yes, I
Okay.
will.
Good luck to you, ma'am. No more panhandling.
Yes, ma'am. I promise I'm done.
Okay.
Promise.
Judge, there's an Attila Kennedy on page 7 of the docket. I'm not sure if she was medically reset from yesterday. I'm not sure if her reset again today. Okay.
All right, Paula, Rackle, call her name. All right, so Joseph, you're gonna have to help me out with this name.
Philocles Joseph, he's in the main jail, Judge. He's on page 9 of the docket.
Thank you.
You're welcome.
Mr. Joseph Philocles, please.
Yes.
Good morning, sir. You are charged with a capious misdemeanor. It's actually for, let me just look at this.
So public indecency, Your Honor.
I know, I just I see what it was, okay. All right, so you're charged, sir, with public indecency. Would you like to resolve your case today, or are we
Yes,
gonna
Judge.
talk about release?
Judge, I spoke with him, and Mr. Joseph desires to resolve this. He has some other issues that he has to deal with, and he wants to focus on those issues. So if the court is inclined, I would ask the court to withhold and take judicial notice of time served.
All right, raise your right hand. Do you swear and/or affirm to tell the truth, Mr. Joseph?
Yes.
Okay, it's Philocles Joseph, Joseph. Your last name is Joseph?
My last name?
Yes.
Joseph. Exactly.
Okay, put your hand down, sir. It's my understanding, sir, you wish to resolve your case today of public indecency?
Yes, please.
Is anyone forcing you to do this?
No.
Are you under the influence of any drugs, alcohol, or medication?
No.
Want to plead guilty, not guilty, or no contest?
No contest.
Okay, and that's the public indecency, urinating in public?
Yes, because I had a
Okay, okay. Ipamare ayen. Papale.
Okay.
All right. Court's gonna withhold adjudication. Court costs $78. Judicial notice of time served.
Judge, will you give him 6 months to pay?
Sure.
Thank you, Your Honor.
Thank you. Good luck to you, sir.
Thank you, Judge.
Dean Herman Alexander. Mr. McLaurin's, come here for a second. Dean Herman Alexander, sir.
He's here present, Judge?
All right, sir, you have a capious misdemeanor for petty theft. Bond's been set at $500. Anybody wish to be heard?
Yes, Judge, and speaking Mr. Alexander, he wishes to ask Your Honor if you would consider resolving the case for time served.
State,
One moment, Your Honor.
did you talk to him about if he gets on his third conviction of a theft, can be charged as a felony?
He understands.
Okay.
Your Honor, I reviewed the state's file.
Sure.
The state's offer. One moment, Your Honor.
Okay, Michelle. Right.
Your Honor, it appears, and I'm checking, confirming this right now, but it appears. No, I understand, Your Honor.
No, I'm not lessening it, I'm just telling you what it is. It was
Yeah.
Walmart. Can you print that out for me, please?
2, 3.
Have a good weekend, everyone.
Thank you. You too, Mr. McLaurin.
It's not over 20 minutes. I'm gonna knock it down, but. Not my Your Honor, I'm showing that Mr. Alexander has approximately 7 or 8 prior theft-related offenses. State's offered to be 10 days.
Spence?
Judge, Mr. Alexander is 54 years old, on disability. Yes, he has prior, from what he advised me, it's not recent. Judge, my understanding is I believe this allegedly took place at a Walmart. I believe he was hungry. I believe the item in question was beef jerky. Judge, considering, like I said, food can be argued as a necessity. I know it's against the law, Judge, but would Your Honor consider time served? What he informs me, he has a host of medical issues. Considering the item which was taken, Judge, I'd actually consider time served.
Okay, so it would essentially be 2 days Broward County Jail.
2 days? Let me talk.
No, because I'm just saying credit for he was arrested yesterday and today is 2 days. So,
Well, yeah, and it was originally an NTA. I don't think he's been previously arrested and got any time.
all right, adjudication time served, no return to the Walmart. Okay, sir, raise your right hand. Do you swear and or affirm to tell the truth?
Yes, ma'am, I do.
All right.
I'm not holding you, man. You guys speak up.
All right, I'll speak up. Put your hand down.
Yes, ma'am.
All right, is your name Dean Herman Alexander?
Yes, ma'am, that's correct.
Alexander?
Yes, yes, ma'am.
All right, make sure you let me know if you can't hear me. It's my understanding you wish to waive your right to a trial in this petty theft case.
Yes, ma'am, that's correct.
Anybody forcing you to do this?
No, ma'am, Your Honor, they're not.
Are you under the influence of any drugs or alcohol?
No, ma'am. I'm in chronic pain and I'm just need to go in a hospital.
All right, have you ever been treated for mental illness?
Yes, ma'am, I have.
Does your mental illness affect your ability to understand what's going on here today, sir?
No, it does not, ma'am.
You understand that if you get another theft charge, they can charge it as a felony,
Yes, ma'am, I understand that.
even
yes,
if it's a beef jerky.
Well, yes, ma'am.
You understand that, right?
Yes, ma'am.
All right. How do you want to plead? Guilty, not guilty, or no contest to petty theft, sir?
Guilty, Your Honor.
Court's going to accept your plea, find that's freely and voluntarily entered. The court has reviewed the court file, finds probable cause for the plea. The court's going to adjudicate him, time serve him, $293 in court costs. You have 30 days to appeal the sentence to the court. If you can't afford an attorney, one will be appointed. Sir, you're not to return to the Walmart at 3001 North State Road 7, Lauderdale Lakes. Let me just tell you one other thing, sir. You know, just because you're hungry is no excuse. You have services. You can speak to Bob at the release desk at the jail when you're released, and he'll tell you about the services that are available for you, okay?
Yeah. Ma'am, I'm aware of that, ma'am, but I'm disabled. I have no transportation. The quick thing with noses is stop providing transportation.
Okay.
I'm very stout. I've gone to a psychiatrist. I said I want to see a psychiatrist. The man hooked me up because I didn't know how to just got on the phone with a psychiatrist, tried to charge my Medicare. I told him I don't have Medicare. And I thought that was illegal, so I just,
All right, so this is what I want you to do. When you're getting released, ask for Bob and speak to him, okay?
Who's Bob? Who's Bob?
He's the gentleman when you get released. He's a gentleman that's by the stairwell, and he's sitting down. That's where you can be by, okay?
Talk to him. He'll tell him your issue and he'll offer you assistance, okay? Tell you where you can get assistance. Thank you. All right, thank you. John Edward Mortimer? For Bob.
It's like understood at this point.
Mr. Mortimer, please. He did? Okay, thank you. Okay, Mr. Romero, Mr. Mortimer posted his bond. All right, so it's 10:15. We're gonna take a break. Okay? So everybody gets a break. Pardon? Yes. All right, thank you. Take your time. Mr. Romero, when he would take a break, if you could just come back and let me know when you're ready, okay?
Judge, by the time I get my ID locked out, my 5 minutes over, so then I would have to come back, so I would be late. So I just stay here in the courtroom.
You wouldn't be late. You can take a break for 15, 20 minutes if you need. How much time you need?
Me, Deputy Johnson, you want to weigh in on this? No? No. Yeah, I know you guys don't get a break, DMH. Judge, no, it doesn't help the situation.
Okay, I just want to give you guys breaks, so that's what you requested, and I don't have a problem with it, so let me know, okay? All right, so Anthony Thomas, please.
Confer, Your Honor.
Thank you. Hello. All right, Mr. Thomas.
Good morning, ma'am.
Good morning. You have an ad charge, count 3, a capious felony. You get to the charge, sir, one moment, for possession of, state, what is this?
It's a change of charge, possession of substituted cathinones.
Okay,
He's being held no bond on counts 1 and 2 for possession of firearm by convicted felon, possession of cocaine.
all right, sir, you are going before your division judge, Judge Dennis Bailey, on April 17th, which is this coming Tuesday,
I think we
at
filed it as a
8:30 a.m. Defense, Mr.
Your Honor, in light of the fact that Mr. Thomas has no bond holds on count 1 and 2, I'd ask you to leave the bond in place on count 3.
All right, so court will set the bond since he has a no bond hold. Court will set his bond at $9.99. Thank you. That's just to let me know, sir, that you have a no bond hold, okay?
Okay.
Thank you. All right, Michael Lewis Graham, please.
Angel?
Okay. Okay, Mr. Graham. You have a petty theft, second degree, third subsequent offense, $750 bond. You have fraudulent use, possess ID of another person without consent. On actually counts 2 and 3, $1,000 bond each one. Counts 4 and 5 are the same as well, which are possession or altered bill or promissory note, $1,000 bond on each one. Any objection to probable cause?
It's a little hard to read, but no.
Yeah. Lighthouse Point is definitely, we're gonna have to call them up too, Michelle. Look at this. Lighthouse Point, if they could remove the black. I don't know. That's something they can change. Okay, in any event, the court's gonna order no victim contact, direct or indirect, sir, with the alleged victim, with the initials KC. I don't know if you heard me say what that was before. Sir, meaning direct or indirect, that means no contact in person, calling, texting, writing, or through third parties. Do you understand?
Yes, ma'am.
All right, anybody want to be heard with regard to the $5,750 in bond or any other conditions?
Judge, in reference to the bond, Mr. Graham is going to be asking the court to consider releasing him on pre-trial release. Right now, from what he advised me, he doesn't have the money to post his bond. He's self-employed. He basically waxes boats for a living. He lives with his mother and his 15-year-old son. His mother works at AC True Value hardware store, and she's a cashier there. He does not believe that she has the financial ability to post his bond, so that's why he's requesting to be released on pretrial release.
Your Honor, I'm going to be requesting a $1,500 bond on count 1. Mr. Graham is out on bond right now for felony theft before Judge Tim Bailey. Additionally, he has theft 2014, grand theft 2012 with the possession of oxycodone. He violated probation. Possession of oxycodone 2010, resisting without violence, DUI 08. End of record.
Does he work?
Yes, he does, Judge. I say he waxes boats for a living.
That's right, you did.
sit on the first row right here.
He gets on an average about $300 per week doing that.
Says his address is 5121 Northeast 27 Terrace, and then it says Northwest 27 Terrace. Which one is it?
It's 5121 Northeast 27th Terrace, Lighthouse Point, Florida 33064.
Okay. Let me just make a note of it here, sir.
Thank you.
That way. There you go. Good job.
And that's Northeast 27th Terrace, correct?
5121 Northeast 27th Terrace. Yes, ma'am.
All right, sir, so there's no contact, direct or indirect, with the alleged victim, KC. The court is going to keep the bond on count 1 at $750, and counts 2, 3, 4, and 5. The court will do $500 each. So it's $2,750. I'm sorry, $1,750. Thank you, sir. Good luck to you. Norris Smith, please. Norris Smith. All right, Mr. Smith, you have a court order. It's by Judge Dennis Bailey. You're going to appear on April 13th. It says at 1:30 p.m. So you'll be going to Judge Bailey today at 1:30, okay? Thank you, sir. Good luck to you. Next one is Paul Ridgely, please.
Mr. Ridley, come on up, please. He's approaching, Judge.
Okay, Mr. Ridley. You have count 1, criminal mischief, over $1,000, $500 bond. Count 2 is resisting an officer without violence. There's no bond attached to that. The court does find probable cause. Court is going to order no victim contact, direct or indirect, sir, with the alleged victim with the initials LG. Do you understand?
Yes.
Did you hear me tell the other person right before you what direct and indirect means? It means no in-person, writing, texting, calling, or third-party contact.
Right.
Okay, so no victim contact, direct or indirect, with LG. Court is going to also order for you not to return to the Burger King located at 7860 West McNabb Road. Do you understand that as well, sir?
Yes.
All right, anybody want to be heard with regard to the $500 bond?
Yes,
The
Your Honor.
defendant is currently being supervised by pretrial service. He was placed on pretrial on the 26th of March by this court. 1 count of petty theft, 1 count of resisting merchant without violence. Case number 18-2721 MM10A. Based on this court's finding of probable cause, we're going to ask that his pretrial status be revoked at this time.
And
Okay.
Your Honor, additionally, the state is going to be requesting a $1,500 bond on count 1. 5 days before he was arrested on the case he's currently out on pretrial for, he pled out a criminal mischief, theft, and resisting a merchant where he allegedly stole from a Walmart and smashed out one of their front door windows. 5 days later, he's arrested on another theft and resisting, and now he's back for criminal mischief, destroying someone else's property. He also pled out a criminal mischief and theft in separate cases last year.
Judge, Mr. Ridley did inform me, unfortunately, financially, he's unable to post his monetary bond. There's no one that can post his monetary bond. He's requesting to be released R1.
Post any bond?
No, no.
Okay, this is the option, ROR, GPS level 2. Court will take no action on the other one. You can send it to the assigned division judge. Thank you.
And Your Honor, the state would object.
I understand.
I know, but I'm gonna, if I may make a record, Your Honor.
Sure, no problem.
Your Honor, and I would note he was placed on pretrial at a second look, Your Honor. And the court, on these cases, advises the public defender to advise their client what happens if they violate their pretrial with another arrest.
Okay.
And now he's before you on another arrest, and the court is taking no action.
I'm not taking any action on, I'll leave it up to the division judge.
And I would object to that, Your Honor, when it's this court, out of this division, placing these individuals on pretrial release.
I understand. Thank you. All right, Michael Giovanni Hurtado, please.
Mr. Hurtado, come on up, please.
Hey, Mr. Hurtado, you have burglary, unoccupied dwelling, unarmed.
Yes, ma'am.
Court does find probable cause. Court's going to order no return, sir, to the Apollo Middle School, 6800 Arthur Street, Hollywood, Florida. Do you understand that, sir?
Yes, ma'am.
Okay. State.
One moment, Your Honor. I don't have anything. I don't know if pretrial has any criminal history.
I have no record.
State would be requesting a $3,500 bond, no return to Apollo Middle School.
Depends.
Judge, we're going to be asking Your Honor to consider a $1,000 bond. This is Mr. Hurtado's first arrest ever. He's 19 years old, been living here in South Florida his whole entire life. He graduated from MacArthur High School at this time. He is employed. He works at Dunkin' Donuts, making $8.50 an hour. He's going to be attending Broward College start fall of 2018. He lives in Hollywood. Judge, we'd be asking you to consider a $1,000 bond on this case.
Court's going to do a $2,500 bond, no return to Apollo Middle School. Thank you.
Good luck, sir.
You know what? Let's get Paul Ridgely back. I have something else I want to do. Let's get him back here. Madam Clerk, can I have that? Just thought of it. I'm giving him a curfew. Paul Ridgely.
Come on back, sir.
Okay, Mr. Romero, just so that we're all on the same page. Does your client work for a living?
No, he does not.
All right, so we're gonna do a curfew from 6 p.m. to 7 a.m. Okay?
Judge, I don't know if I informed Your Honor, but I believe that he was financially indigent and he is homeless.
Does he have any place he can live?
I'll ask you again, Judge. Nope. No, Your Honor.
All right, then what I'll do is, the only thing I can do is then I'm gonna give him a bond of $1,500.
So the level 2 pretrial is deleting, Judge?
I'm gonna delete it, and I'm gonna put, I'm not taking away no victim contact and no return to Burger King. Then what I'll do is a $1,500 bond, standard pretrial release. I want him reporting one time a week in person, calling in one time a week. And he's still to have a curfew from 6 p.m. to 7 a.m. Okay? Thank you.
Judge, Mr. really raises a valid point. How, a curfew when a person is homeless, I don't know how that works.
Well, he's probably going to remain in jail. I don't think he's going to be able to make that bond, so I guess he has to be in his bunk by 7 o'clock.
All right, so you know what, Mr. Reedy, I'd appreciate if you didn't make those type of comments. May I have the paperwork back, please? They're not appreciated. Okay, so what the court will do is delete the curfew. Thank you, $1,500 bond. So, standard pretrial releases.
But delete the curfew.
Yes, thank you. All right, Thaddeus James Wolf, please.
Come on up, sir.
Okay, Mr.
Check
Wolf.
for outside of Broward on him.
You have count one, petty theft, first degree, between $100 and $300. There's no bond attached to that, sir. And then you have count two, exploitation of the elderly, less than $20,000. The court does find probable cause, unless I hear something to the different.
Judge, I don't know how this is exploitation of the elderly. He stole a bike, and the victim, I guess, is disabled, but I don't know how that's exploiting an elderly person.
State?
First of all, I think it's pretty clear from the probable cause affidavit that it's a crime of opportunity. Mr. Wolf would not have known that the individual who owned the bike suffered from any type of disability.
Right, in any event, sir, while they're looking that up, there's no victim contact. I do find probable cause on the petty theft. No victim contact, direct or indirect, with the alleged victim with the initials LC. What that means, sir, is, I don't know, did you hear me before what direct and indirect means?
Yes.
All right, so just no contact, and I don't want you returning to 1681 Southwest 7th Drive in Pompano, okay?
Yes, ma'am.
Your Honor, I'm going to be asking for 24 hours on count two.
Okay, 24 hours to perfect on count two. In the meantime, we need to set some type of bond, not a punishable by life offense. So, what do you recommend as far as bond at this point, Mr. Linder?
I'd be asking for a $1,000 bond.
Judge, unfortunately, at this time, Mr. Wolf, my initial intention was to ask for pretrial release. Right now, he's a handyman. He's looking for work. What he does on the side is manual labor type of employment. That's his trade. He's 56 years old, been living in our community now since 2006. He lives in a trailer in Pompano Beach. He's been there for about 2 months with his girlfriend. His girlfriend is not employed, so therefore at this time he's financially indigent. But
All right, I have two different addresses. 1640 Northwest First Ave, and then I have 1500 Northwest 15th Ave.
is that correct? Judge, the first one that you read off is an old address. The second one is correct address.
All right, let me just verify and say the whole thing again, sir. 1500 Northwest 15th Ave, Pompano Beach?
Yes, ma'am.
All right, and how long have you resided there, sir?
2 months.
All right. All right, this is what the court's gonna do. The court is gonna set bond at $1,000 and 24 hours to perfect. No victim contact and no return, sir, to the 1681 Southwest 7th Drive, okay? Thank you, good luck to you. Jake Patrick Dunbrook, please. Hello, Mr. Dunbrook. You have count one, possession of...
Judge, he has private counsel.
Okay,
The client, what was the You told my colleague, I didn't get it.
Yeah, I had him on my BOP in my other cases, and I asked that, I don't have a public record on my new charge.
So you're applying for public counsel? Okay, no problem. Yeah, okay. I'm sorry, Judge, we're ready.
Double check.
okay. Mr. Dunbrook, you have count one, possession of heroin. Count two is possession of cocaine, thank you. Both have $1,000 bond attached to it. Count three is driving while license is suspended. second offense, $100 bond. Count 4 is a civil traffic infraction. It's not for today, improper change of lanes. However, count 5 is a probation violation where you're going to be held no bond. You are going before your division judge, Judge Michael Rothschild, on April 17th, sir, at 9 a.m. on your probation violation, and that's this Tuesday. Court does find probable cause. Anybody want to be heard with regard to probable cause?
No, Judge.
Okay. Anybody want to be heard with regard to the $2,100 in bond?
No, Judge, considering as a no bond holder, that's Tuesday.
Okay. Count 1 is $999. Count 2, $999, and count 3 is $99. Thank you very much, sir. Good luck to you. Next one is Rudolph Jean Baptiste, please.
He's here present, Judge.
Good morning, sir. How are you?
Good morning, Ron.
You have possession of MDMA, ecstasy, $1,000 bond, and count 2 is a civil traffic infraction. It says engine run, set brake. Court does find probable cause. Bond set at $1,000. Can you afford that, sir?
Yes, Judge, his mother will be posting the bond.
All right, let me just verify your address, sir. I want to make sure you get notices, because I see 2 different addresses here. One is 3520 and the other one is 6001.
6001, ma'am.
North Circle Drive, Lauderhill?
Yes, ma'am.
All right, thank you, sir. Good luck to you, okay?
Thank you, ma'am.
Do you have you been able to speak to your mother, sir?
I'm trying to speak to her now, ma'am. She should be posting any minute now, ma'am.
Oh, you did speak to her?
Yes, ma'am.
All right, just wanted to make sure. Okay, thank you. All right, Mark Thomas Glyer, please. Hello, Mr. Glyer. You have 1 count, burglary, unoccupied dwelling, unarmed. We need to talk about bond. Count 2 is possession of burglary tools with intent to use. Counts 3, 4, 5, 6, 7, 8, 9, and 10 are all no bond holds for probation violations. You are going before your division judge this Tuesday, Judge Michael Rothschild, at 8:30 a.m. State, what are you requesting as far as count 1 and 2?
Your Honor, considering that it appears, I'm not asking for any different bond on count 2. Just considering the how many different cases he's on probation for at this point in time, and that they are, one of them it looks like he's got a suspended sentence, Your Honor, on, or he's, either that or he was placed on probation on the 2017 cases on March 5th of this year. I'm going to be asking for $20,000 bond on count 1.
Judge, concerning he's being held no bond, I'm going to be asking for $3,500.
All right, sir, this is what the court's going to order. No victim contact, direct or indirect, with the alleged victim with the initials MC. That means no contact in person, calling, texting, writing, or anything on social media or through third parties. You understand? The other one is no return to 3212 Northeast 12th Street in Pompano. Also, the court's going to put you, if you do bond out, and the court's only doing this obviously on count 1 and 2, the court is going to set a $20,000 bond on count 1, and count 2 the court's going to set at $999. Thank you, sir. Good luck to you. You'll be before Judge Rothschild on Tuesday. Michael Edward Flanagan, please. And then we have Ronald Lalaine.
Mr. Flanagan, come on up, please.
All right, Mr. Flanagan, good morning. You have count 1, illegal use of credit card more than 2 times in 6 months, $100 plus $1,000 bond. Count 2 is fraudulent use, possess ID of another without the consent, $1,000 bond. Court does find probable cause. Court's going to order no victim contact, sir, direct or indirect, with the alleged victim in this case, with the initials BM. Do you understand, sir?
Yes, Your Honor.
Okay, excuse me. Does anybody wish to be heard with regard to the $2,000 in bond?
The only thing I would point out, Judge, is that Mr. Flanagan did cooperate with the police once he was apprehended and did admit his wrongdoing.
Okay. Anybody wish to be heard further?
Yes, Judge, in reference to the $2,000 bond, unfortunately at this time, from what he advised me, there's no one really that can help post his monetary bond. More importantly, I believe this is his first time being from with his roommate. Their monthly rent is $750. He's lost his job. Therefore, considering what my colleague stated, Judge, that he cooperated with law enforcement, this is his first contact with the criminal justice system. I'd ask you to release him.
All right, sir, it has your address as 7570 in Hypoluxo. Do you live in Boca Raton or Hypoluxo?
Hypoluxo is my mailing address. I just moved in my apartment about like 2 days ago, so I don't know the correct address for that apartment.
All right, but you can get your address here.
Yeah.
Your Honor, I just want to note for the record, the only issue I have, I don't know that the fact that he lost his job is really a mitigating factor in this case, considering it would appear that he used the information he was able to obtain from this job to obtain the victim's personal information.
So what are you suggesting?
Your Honor,
He has no prior record, right?
he has no record, Your Honor. I think a combination of bond and pretrial would be appropriate based on the nature of the allegations.
Can he afford any bond?
No, that's why we were asking for pretrial. With the bondsman, judge is going to be $200. So, I mean, I'd ask you, one, he cooperated with law enforcement, judge, and this is his first offense. I think it's reasonable to ask for standard pretrial.
Okay, sir, your address is, can you still get mail at the 7570 South Federal?
Yes, ma'am.
All right. So if you change your address, sir, it's your responsibility to notify your attorney and the clerk of court in writing along with your case number, okay, immediately. And you can also go to the browardclerk.org and look up your court date. Court is going to ROR you, sir, on each count and put you on standard pretrial release. You are to notify pretrial release of your new address immediately upon release. And the other thing is, I want you reporting 2 times a month, sir, okay? In person. Otherwise, it's reporting 2 times a week. Mr. Romero will explain to you about reporting within 24 hours, not including this weekend. Thank you.
As soon as you get released today, you're going to
Ronald Lane, please.
where the map indicates. If you get released after 3, they're closed. Report by noon or on Monday.
Okay, Mr. Lane, how are you, sir?
I'm fine with it.
Good, sir. You are charged with 1 count of grand theft auto, $1,000 bond. Counts 2 and 3, sir, you do have probation violations where you're going to be held no bond. You do have a hearing coming up before your division judge, who is Judge William Howry, Division FC, this Tuesday at 8:30 a.m. Court does find probable cause. The court's going to order no victim contact, sir, direct or indirect, with the alleged victim with the initials JAS. Anybody wish to be heard with regard to probable cause or $1,000 bond?
The defendant is currently being supervised by pretrial service in case 17-14205 CF10A. He was placed on pretrial on the 19th of December. 1 count of grand theft, 1 count of dealing in stolen property. Based on this court's finding of probable cause, we're going to ask that his pretrial status be revoked at this time.
Okay, the court will revoke his pretrial status in 17-14205 CF10A. Court will set $1,000 on that bond, and on count 1, in this case, court is inclined to set $1,000 bond. Anybody wish to be heard further?
No, Judge.
And I stand corrected. For the dealing in stolen property, court's going to set bond at $1,000. The false ownership info, the court will set bond at $100. And in this instant case, the grand theft auto, court will set bond at $999. And for the 2 probation violations, it's obviously no bond. Thank you, sir. Good luck to you. Gardy Hertz Vincent, please.
Bonded, Judge.
Thank you. Bart Paul Joseph Jono, please, and then Robert Michael Burke.
Mr. Jano is here present.
Okay, Mr. Jono, you have count 1, deliver heroin within 1,000 feet of a place of worship or business, bond set at $7,500. Count 2 is sell cocaine within 1,000 feet of a place of worship or a convenience business, $7,500 bond as well. Court does find probable cause. Anybody wish to be heard with regard to the $15,000 in bond?
Yes, Judge, Mr. Jano is gonna be asking me to request pre-trial release. He's, 33 years old, been here his whole life. He is working. He works for, Farmer's Touch. He's a laborer. He's been there for about a couple of months. He averages about $100 a day working there. He lives with his, parents in Davie. Been residing at the same location for about 6 years. From what he advised me, that his parents cannot afford to post his bond. Therefore, he's going to be asking you to consider releasing him on pre-trial release, Judge.
Your Honor, I'm requesting the court to keep the standard bonds in place. Mr. Janot's criminal history includes 2015 burglary of a conveyance and grand theft. He violated his probation, was sentenced to 364 days county jail. 2014 criminal use of personal identification information and credit card fraud, violated his probation, 364 days. 2010 grand theft with a violation of probation, 2 years state prison. Grand theft 07, 2.5 years state prison. Carrying concealed weapon 03. 2003 possession of cocaine with intent to sell or distribute. He violated probation, 2.5 years state prison.
Okay, defense?
Just relying on what I said before, Judge.
Okay, court's gonna set bond on count 1 at $3,500. And on count 2 at $1,500. Court is gonna do a GPS open schedule. Thank you.
Your Honor, state would oppose the open schedule considering the nature of his charges.
Thank you. Robert Michael Burke, please.
Mr. Burke, come on up, please.
Okay, Mr. Burke, you have count 1, possession of cannabis, 20 grams or less. There's no bond attached to that. You do, however, have count 2, trafficking in oxycodone between 7 and 14 grams. Bond's been set at $75,000. The court does find probable cause. Anybody wish to be heard?
Yes, Judge. Mr. Burke, we're going to be requesting you to consider reducing the bond. He's 25 years old, been here his whole life. He works for a company called Quality Sandblast, and he's been with them for about 5 years now, making about $14 an hour. He lives in Davie. He lives with his roommate, been living there about 4 years. His share of the rent is $720. He's going to be reaching out to friends, family, his roommate, everyone to see if they can post his bond. Right now, his family lives in Palm Beach. From what he informed me, his mother works, but part-time. She's renting her apartment. Judge, he also informed me that he does have priors. This isn't his first offense. However, from what he advised me, in 2012, he was placed on probation, and he successfully completed probation. So, Judge, he's not a flight risk, strong ties community. We'd be asking you to consider $10,000 bond on count 2, along with free trial release.
Anything further, state?
One moment, Judge. Your Honor, while I'm checking, I would note the probation that Mr. Romero referred to. Mr. Burke did violate that probation at one time, and he did, after that, end up completing his probation. I would just ask the court, when setting a bond, also to weigh that even with just the one prior, and that was a grand theft, if convicted of the trafficking, he faces a 3-year minimum mandatory prison sentence.
All right, GPS level 2. Count 1 is basically an ROR. Count 2 is with the trafficking from $75,000 to $25,000. Thank you, sir. Good luck to you. Zikria. Zikria, right, sir?
Zikria, right? Yes. Okay.
All right. All right. Good morning, sir. You have 1 count of criminal mischief. between $200, oh, I'm sorry, it says $200 or less first offense, basically an ROR. Count 2 is a possession of cocaine, $1,000 bond. Counts 3, 4, and 5, sir, are basically RORs. That's drug paraphernalia, possession of drug paraphernalia, resisting an officer without violence, and loitering or prowling. You do have count 6 and 7. Let me see if there's a second page. Nope. Count 6 and 7, sir, are probation violations. You are going to be held no bond. You are going before your division judge, Michael Rothschild, on April 17th at 9 a.m. Court does find probable cause unless I hear an objection. Court is going to order, sir, no return to the Publix located at, give me one moment, 2633 North Dixie Highway in Wilton Manors. Do you understand, sir?
Sure.
All right. Does anybody wish to be heard with regard to the $1,000?
No, Judge, considering there's no bond hold, but we'd be asking you to sign a photo order.
Sure. Granted. Court's going to set bond on count 2 at $999. You'll see Judge Rothschild, sir, on Tuesday. Good luck to you. Next one is Rashad Antoine Harrington, please.
Your Honor, can we put this case on a brief recall?
Sure.
Sit down, sir.
Thank you.
You can set it for this afternoon if you
No,
want.
no, I just need a brief recall.
Okay. Jeffrey, do you need to take a break?
No.
Okay. Jeffrey Michael Miller, please.
Mr.
Jeffrey Michael Miller. Okay.
No, what page are you on?
It's page 26 for Mr. Miller.
Okay. Mr. Robinson, come on up. You should be next.
Brandon Towin Robinson, please.
Yes.
Hello, Mr. Robinson. You have one count of possession of cocaine, $1,000 bond. Count 2 is resisting an officer without violence, and loitering or prowling are basically no bonds attached to them. Court does find probable cause. Does anybody want to be heard with regard to the $1,000 bond or any other issue?
No, Judge.
Okay, sir, the court's going to order no return to the Sunoco gas station at 1501 South Cypress Road, Pompano. Do you understand?
Who's this? Who is this?
This is Braden
Thank you.
Robinson. You want to be heard on him? PD has no objection to the $1,000 bond. Okay.
I'm not asking.
Thank you, $1,000 bond. Perry's.
What happened to Jeffrey Miller?
Talia?
Jeffrey Miller.
Are you Mr. Aptopoulos?
Did he bond?
Yes.
How do you say it, sir? Okay, Appolitas, I'm sorry about that. Sir, you're being charged, good morning. You're charged with one count of possession of cocaine, $1,000 bond. Count 2 is possession of drug paraphernalia. There's no bond attached to that. Court does find probable cause. Anybody wish to be heard?
Not as far as probable cause.
All right, what about bond for $1,000?
Yes, Judge. And esteemed Mr. Appolitas, he's asking Your Honor to release him on pre-trial release. He's 42 years old. He's working for Police Cutters. He gets paid about $60 to $80 a day. He lives in Fort Lauderdale with the child of his children. Judge, right now, his child, the mother of his kids is the only person that can post his bond. She does nails for a living, so he does not think that she can afford to post his bond, so that's why we're asking for pre-trial release.
One moment, Your Honor.
Break? Just let me know. I know I keep asking, but I don't want to hear I don't give people breaks.
Looks like he's on probation right now before Judge McHugh. Your Honor, it appears that he is on probation right now before Judge McHugh for domestic violence, battery, and criminal mischief.
Okay, I'm sorry, he's on probation?
Yes.
Okay.
In light of that, I think the $1,000 bond is reasonable. He's already violated his probation once.
See you Tuesday. Okay, anything further, defense?
No, we're just gonna keep on asking for pretrial release on it.
$1,000 bond, thank you.
Yes, sir.
Jasant Josta Aristo?
Tommy?
Sure. Okay,
How you doing?
good, how are you, sir?
All right.
Are you Jasant Josiah Aristo, sir?
Yes, ma'am.
All right, you have count 4, robbery with the firearm, there's a no bond hold. Count 6 is a capious felony for $1,000. That's actually an add charge for the robbery with the firearm. That's a change of charge from carjacking. So capious, add count 2, and change of charge for count 1. Is that correct, State?
Yes, ma'am.
All right.
Your Honor, I provided the court with paperwork. I showed it to Mr. Reedy. It's just a copy of the original findings, the information that was filed in the original PC affidavit. Your Honor, he was ordered to be held no bond on the carjacking with a firearm or weapon. It's now, the allegations in this case, I believe, have to deal with property that was stolen from the car. So we're just asking the court to make a finding of proof evident or presumption grade for first appearance purposes and.
Just for count 4, though?
Yes.
For the robbery?
Yes.
Okay. All right. Defense?
Your Honor, in light of the fact that Mr. Aristotle currently has other no-bond holds, I believe there's a no-bond hold on count 3, we would reserve any argument regarding proof evident presumption grade until Mr. Aristotle can appear for a Arthur hearing before his division judge.
All right, Mr. Aristotle, I have reviewed the affidavits and information filed in your case, and I find probable cause. I further find the proof of guilt to be evident or the presumption great. Therefore, on the robbery with the firearm, you are going to be held no bond. On the capious felony, the court is going to set your bond at $999. You are going before your division judge. You'll see him on Monday at 9 a.m. Good luck to you, sir, okay? Thank you.
Thank you.
Thank you.
Your Honor,
Do we have to say any victim contact or anything, or no?
it's already been ordered, Your Honor.
Okay.
Your Honor, if we can go back to Rashad Harrington.
Sure. Hey, Mr. Harrington, hello.
Your Honor, I've been in contact with Detective Willis from Broward Sheriff's Office, and I'm requesting for him to provide me more. I'm going to ask that this could be reset for tomorrow morning to provide more information to the court.
What's tomorrow, 4/14?
Yes, ma'am.
Today's Friday the 13th.
Yes, it is.
Okay, for state to what? What do you just?
I just want to provide more information, Your Honor, specifically with regards to which park this was, the distance, but also additional information.
I'm just going to put more info. I just wanted to put it on the sheet for
Sure.
the judge tomorrow, so. All right, there you go on that one. Then we have, so, sir, this is going to be reset for tomorrow, okay, in the morning? Because the state attorney needs additional time to provide more information, okay?
Judge, in the meantime, would you consider them reducing the bond?
No, sir, not until I get more information. Thank you. Andy Perez, please.
Make sure, Andy Perez is here present, Judge, you declined to serve as a public defender.
Okay, Mr. Perez, you're charged with, these are ad charges? Yes. All right, so count one is burglary, unoccupied conveyance, unarmed. We need to talk about bond, and count 10 is a capious felony for a burglary of a conveyance unoccupied. Is count 10 the capious? Is that a change of charge?
It's
Do
an
I
ad,
set bond?
it's an ad charge.
Okay,
Your Honor, if I may,
sure.
count one, it's a change of charge. Your Honor originally, set the, bond at 20,000 pursuant, and I think that was pursuant to an arrest warrant. I'm gonna be requesting the court to set the bond back at 20,000. Just wanna see what else is going on here. He's being held on a grand theft auto for 7,500, and he's got numerous violation and community control holds.
Okay, so he has no bond holds?
Yes, he does.
Okay.
So, and it did, on the ad charge, on the capious, it's charge 3, on the booking, it's charge 10. I'm gonna be requesting a $7,500 bond, which is the same amount of bond you set on the grand theft auto.
Okay, sir, so they're asking for a $20,000 bond on the burglary and $7,500 on the capious felony. Doesn't say grand theft auto here, it says burglary of a.
No, I was referring, he's also being, we filed a grand theft auto, he's already being held on that. I was just referring to that as a reference for the bond.
All right, so you're asking for 20,000 on the burglary, on the change of charge, on the count 1 on this sheet.
Yes,
And count 10, you're asking for 7,500.
yes,
All right, sir, they're asking for $27,500 in bonds on the 2 counts, 20,000 on 1, 7,500 on 2. Would you like to add anything? All right, this is what the court's gonna do. The court is gonna find probable cause. And on the change of charge, the burglary unoccupied conveyance, the court's gonna set bond at $10,000, considering he has a no bond hold. And on the capious felony, the court will set it at $7,500. All right, sir, good luck to you. Call your public defender or an attorney. Lubins Timothy. Hello. Good. You have count 1, manufacture cocaine within 1,000 feet of a school, child care, or park, $7,500 bond. Count 2 is neglect a child without great bodily harm. We need to talk about bond. Count 3 is driving while license is suspended. Third or subsequent offense, which is being charged as a felony, $750 bond. Count 4 is sell heroin within 1,000 feet of a school, child care, or park, $7,500 bond. Count 2 is sell Schedule 1A and B drugs, $7,500 bond. And count 6 is sell cocaine within, it says 100 feet. I have it right. Within 1,000 feet of a school, child care, or park, $7,500 bond. Then we have count 7, sell heroin within 1,000 feet of a school, child care, or park, $7,500 bond. And count 8 is sell Schedule 1A, B, D2A drugs, $7,500 bond. Count 9 is sell cocaine, the same as count 6. Sell cocaine within 1,000 feet of a school, child care, or park, $7,500 bond. You are being held no bond on counts 10 and 11. I don't have a date. It says 4/16 here, April 16th at 9 a.m. before your division judge, who is Judge Michael Usan, at 9 a.m. this Monday. Court does find probable cause. State.
Your Honor.
Here we have to say on 2 and any other bond.
Your Honor, I'm requesting a $5,000 bond on count 2
Okay,
with an order of no victim contact with RT.
okay, hold on, no victim contact with RT,
Yes, ma'am.
Romeo Tango?
Yes, ma'am.
All right. All right, sir, the court's gonna order no contact, direct or indirect, with the alleged victim in this case, with the initials RT. That means no contact in person, calling, texting, writing, anything on social media, and no contact through third parties, you understand?
Do you understand?
All right. All right, so, defense, what's your position on bond?
Judge, at this I'm considering he has a no bond order, he's gonna have to go to Judge Bouchon anyway. We'd be deferring any argument until he's able to be present in front of his division judge.
All right, so we'll set the bond at $4,999 on 2. Count 3, we'll set it $749. And that's it for now. Thank you.
Yes, sir.
All right, and I'm gonna sign another order on Zeke. All right, we'll be back at court resumes at 1 o'clock. Thank you.